Welcome. Have a seat if you'd like. Were you still planning on having your professional here? Okay, that's fine. We'll go ahead and move forward then. Good morning. This is the case, appeal of Sowila Khan. Ms. Khan, am I saying that correctly?
Yes, Your Honor.
Okay. I'm the lead administrative law judge, Sarah Hosey, and with me today are my panel members, Judges Jeffrey Margolis and Elliot Scott Ewing.
Good morning. Good morning.
So right now we're just off the record. I'm going to cover a few housekeeping items, and then we'll go on the record, and our stenographer will write down everything we say today. If at any time you have any questions, just let me know, and we can answer them as best we can. As I said, I'm the lead judge for the purpose of holding this hearing, but all three of us are equal decision makers when we write the decision. As we discussed at the pre-hearing conference, the issue today is whether the appellant's claim for refund for the 2012 tax year was filed prior to the expiration of the statute of limitations. Ms. Khan, is that correct? Yes, Your Honor. Great. Mr. Patel?
Yes, that's correct, Your Honor.
Okay. We also discussed the exhibits at the pre-hearing conference. We had appellants 1 through 3 and respondent FTBs A through J, and those were admitted through the pre-hearing conference minutes and orders issued on December 4th. Ms. Khan, do you have anything new to present today?
I think there's a miscalculation. That's probably why the extensions weren't applied. So
Okay.
I just wanted to address that. That's it.
Okay, we can talk about that when we're on the record. I want to make sure I get everything down. But you don't have any more documents for us, right? Other than the ones we've covered?
Just my LOA
Okay.
that I wanted to.
All right, and then Mr. Paval, any new exhibits from FTB?
No, Your Honor.
All right, then Ms. Khan will swear you in, just so we get everything under oath, and then you will have as long as you'd like. I gave you a little extra time because I didn't know if your representative would need more time, so take as much time as you'd like. And then Mr. Paval, you will have 10 minutes for your presentation, and then we may have questions, and you will have time for a final statement as well, just to make sure everything is on the record. Okay, anything before we go on the record?
No.
Oh, yes. Oh, sure. Ms. Khan, can you pull it a little closer? Yeah, no problem. Thank you. Okay, we're going on the record. This is the appeal of Sowila Khan, case number 19024361. Today is December 13th, 2019. It's approximately 10:06 a.m. We're in Sacramento, California. I am lead administrative law judge Sarah Hosey, and with me today are judges Jeffrey Margolis and Elliot Scott Ewing. Parties, can I have please state your names for the record?
Sowila Khan.
Shannon Paval, tax counsel for FTB.
And Natasha Page for FTB.
Thank you. The issue we have before us today is whether appellant's claim for refund for the 2012 tax year was filed prior to the expiration of the statute of limitations. Ms. Khan, is that correct?
Yes, Your Honor.
Thank you. Mr. Paval?
Yes, Your Honor.
Great. We marked exhibits 1 through 3 for appellant and A through J for respondent, FTB, at the pre-hearing conference held on December 3rd, 2019. No objections were raised by either party, and exhibits 1 through 3 and A through J were admitted in the pre-hearing conference minutes and orders issued December 4th, 2019. All right, Ms. Khan, are you ready? We're going to swear you in. Can you please stand and raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Please begin. Just take your time.
I was going over everything, and I understand the extensions and the time frames, and I think that maybe there's a miscalculation that it was going off of because my contract, my contract ended in 2014. So as I was calculating, I was going over all the extensions that were being applied, and it looked okay to me, so I'm kind of confused with why it was still denied. Like, I had called 3-4 times, and every representative from FTB had explained to me that, yes, there's no reason you should be denied. They said, do a claim for refund more than once. So I have applied that 3 times. And I even have the letters, and I only got a reply 1 time from FTB after filing 3 times with them.
And when you say filing, is that an actual return?
It's the claim for refund.
The claim for refund itself? Okay.
Yeah.
You have the dates of the claim for refund letters that you sent?
I have 2. I have these that came back to me.
Are those, I don't see those in the documents we have. Are those proof of service?
Yes, Your Honor.
Would you like to put those in the record?
Yes, Your Honor.
Okay, let's do that. I'm going to have copies made so that we can give some to the Franchise Tax Board and the panel members. Let's take 5 minutes to do that.
Yes, Your Honor.
All right, we'll go off the record for a few minutes.
Are there any other documents you have that we should make copies of as well now?
I believe you got, the LOA is probably in there, but.
The NOA, the Notice of Action?
No, my letter
Oh,
of
that-
authorization, my
LOA.
contract ended.
I'm not sure. Why don't we make a copies of that?
Yeah, that's a good idea.
And
Thank you.
And just to be clear, those are certified mail receipts?
Yes, Your Honor. Mhm.
Thank you. Oh, no. Thank you. Okay, we're still off the record, so we can chat about these, just to make sure we're all on the same page. I have a letter of authorization. It's 2 pages. And then I have several different, looks like 1 page of USPS tracking and the certifications. Okay. So I'm going to mark the letter of authorization as Appellant's Exhibit 4. And we will do the combination of the certificates as Appellant's Exhibit 5. FTB, do you have any objections to entering this into evidence, the Exhibit 4 letter of authorization and Exhibit 5 group of certificates from USPS?
I respectfully request a couple of minutes to look at the
Of course.
documents.
Please, take a few minutes. Thank you.
Batting Judge Hosey?
Yes.
I've looked at the documents. We have no objections to the certified mailing receipts,
Okay.
which you've labeled as Exhibit 5.
Yes.
That is fine. I'll just note for the record that what the panel has labeled as Appellant's Exhibit 4
Yes.
is actually a duplicate of the Respondent's Exhibit D, page 9. And I would just advise the panel that some of the documents, I apologize, Your Honor, it is a different document. No. It's not. It is a duplicate of Exhibit D, page 9. With the exception of this front page, there are no redactions made on it. So the back page of what we've marked as of Appellant's Exhibit 5, that's new.
Okay.
So
Do you have any objections to the new material or the unredacted material?
No objections.
Okay, I'm going to go ahead and enter it when we go back on the record, just so we have the back page and the unredacted material that Ms. Khan has presented. Okay, we're going to go back on the record here in 1 second. We'll enter this into evidence, and then Ms. Khan, you can continue your explanation of what these documents mean to you and why you deserve a refund, okay? We're going back on the record. We have previously identified additional documents. We have Appellant's Exhibit 4, a letter of authorization, and Appellant's Exhibit 5, several certified mailing receipts. We have no objections from the Franchise Tax Board, correct,
correct.
Mr. Pavel?
That's correct, Your Honor.
Okay, we are going to go ahead and admit Exhibit 4 and 5 into evidence in the record. Ms. Khan, you are still under oath. Please continue with your presentation.
Okay, over in one of the, what is that, what page is this? It states that your original return was filed on February 22nd, 2013. It says you reported you left Pakistan on February 10th, 2013, and which it says that I had left the combat zone. But that's where the mistake is. I never specified, even in my statement to FTB, the years. It doesn't. I relied on my LOA for it to be calculated. I thought they would go off of the LOA for the years because my contract ended on 2014.
When in 2014 did it end?
October 1st, 2014.
And October 1st, 2014. That seems to be a little bit different than the LOA that you gave us today, which has in the middle of the page, it has a contract to end date of 9/16/2015. So that's, that might be perspective, but it's your recollection that your contract ended in 2014?
Yes, Your Honor.
And you didn't have any additional work through September 2015?
Not with MEP anymore, no.
Oh, okay. Okay, do you have anything else you'd like to tell us or explain, or?
Just that, like I said, in the statement, it doesn't have the time frames as it states in this, so I don't know where the time frame came from.
That's stated in the letter of authorization?
No, on the
Franchise Tax Board's documentation?
Yes, Your Honor.
Okay. Mr. Favell, I'm sorry.
I'm sorry, I have a question.
Go ahead.
The 4 certified mail receipts that you provided to us, can you relay to us what was filed with when you mailed these documents?
Yes, so the first one was me amending the 540, and the second one was a claim for refund, which I had called, and the representative said they hadn't received anything, so to refile again. And then I had refiled again twice.
And from my brief look at the correspondence receipts you gave us today, they were all in 2019, is that correct?
No, I believe 2 of them, I believe they were for 2018. Is it? That's it's when it came back, received by them. One of them is they received it and they sent it back.
About how long did it take for you to get it back after you sent it, in your recollection? A couple weeks, a month?
No, it took months. It took months. I got these after months. Yeah, it states when I got them. One says February, June, April. I got them back after I filed, which was before.
And did you send any earlier correspondence of any kind to the FTB informing them that you had overpaid your taxes for the year at issue, or that you wanted a refund for that year? Or is it just these 3 letters that you gave us?
It's just these 3.
Mr. Favell, did you have any questions for Ms. Khan?
No, Your Honor.
And are there any other questions from the panel?
No.
Okay. Mr. Favell, are you ready for your presentation?
Yes, Your Honor.
Okay, please begin.
Good morning. This panel should affirm the FTB's determination that the 540X was filed outside of the applicable statute of limitations as defined by Section 19306 of the Revenue and Taxation Code. In this matter, the tax year in question is 2012. The original tax return was filed on February 22nd, 2013. That's Exhibit A. An amended 540X was filed by the appellant on October 1st, 2018, which is outside the 4-year statute of limitations. With the original return, there was state income tax withheld in the amount of $16,104. That state income tax is deemed paid at the time the return was due, which would be April 15th, 2013, pursuant to Revenue and Taxation Code 19002, Subdivision C1. And so the amended return filing on October 1st of 2018 bars the FTB from issuing any claim for refund under the 1-year statute of limitations as well, which states that you're allowed to give a refund from 1 year of the date of any overpayment. If the state income tax is deemed paid as of April 15th, 2013, there is the claim for refund must be barred under the 1-year statute of limitations as well. The FTB has looked at the combat zone exceptions in this matter to see if the appellant was entitled to a grant of her claim for refund. The combat zone exceptions are contained in Internal Revenue Code Section 7508 and are made applicable under the Revenue and Taxation Code Section 18571. Section 7508 provides extensions of time for individuals that are in the armed services or supporting the armed services. And the combat zone exceptions toll the time periods while the individual is within a combat zone and after they leave a combat zone for an additional 180 days. In this matter, if you turn to Exhibit A, page 13, for the record, Exhibit A is the original filed return for the appellant. If you turn to that page, it asks for tax buyers qualifying under physical presence test, and it says enter your principal country of employment during your tax year, and it's Pakistan is listed. The date is 1/26/2012, which you will see matches I apologize. It does not match, but the point I was making was that it has a date left, and the date that was provided was February 10th, 2013, and that's the date that the FTB used for evaluating the combat zone exception. Today we've received additional evidence that says in Exhibit 4, that says deployment period end would be 10/1/2014. So assuming that the appellant left the combat zone on 10/1/2014, it would have had another 180 days at that point. And so the combat zone in this case is not applicable in regards to the claim for refund. And so the FTB has looked at the 4-year statute of limitations, which expired on 4/15/2017. So that is not within the statute of limitations. The FTB has looked at the 1-year statute of limitations. There is no payments made within 1 year of the amended filing of October 1st, 2018. And the FTB has looked at the combat zone exceptions. And we cannot find any law that would allow the FTB to grant the appellant's refund. And while we are sympathetic to the appellant, the statute of limitations is a portion of the law that may seem harsh and arbitrary, but it's needed for effective tax administration. Just recently, in an OTA precedent decision, the estate of Barbara D. Gillespie, 2018 OTA-052P, the OTA just reaffirmed the legal principle that absent congressional authorization, courts do not have general authority to abrogate the statute of limitations for a refund claim based on equitable arguments. And so there's nothing that the FTB could do in this case, and it's our position that this panel should take the same position, that absent congressional authority, the OTA is bound to follow the statute of limitations as set forth in the Revenue and Taxation Code. In the OTA decision, both the Dahm case and the Prusner case are cited. In United States versus Dahm, it reinforced the principle that even when a tax is erroneously, illegally, or wrongfully collected, if a refund claim is not filed within the statute of limitations, it cannot be granted. In addition, the Seventh Circuit in the Prusner case eloquently captured what the statute of limitations means, and I will just read it into the record for your consideration. And they state, all fixed deadlines seem harsh because all can be missed by a whisker, by a day, or for that matter, by an hour or a minute. They are arbitrary by nature. The legal system lives on fixed deadlines. Their occasional harshness is redeemed by the clarity which they impart to legal obligation. The government has millions of taxpayers to monitor, and our system of self-assessment in the initial calculation of tax simply cannot work on any basis other than one of strict filing standards. And they're citing United States versus Boyle, citation to that's 469 U.S. 241. Upholding penalty for late filing of a state tax return to extend the time for filing a claim for refund beyond the limits prescribed in the Act is a legislative, not a judicial function. And so, again, while sympathetic to the appellant, there's just no basis to grant the claim for refund. And with that, the FTB submits. Thank you.
Judge Margolis, do you have any questions?
Yes, I realize that the statute of limitations are harsh, but the case you cite doesn't involve a tolling provision. I'm just wondering, do you have any authorities to discuss how the tolling provision is applied in this case? I mean, if she had 4 years from the date of the return was due to file a claim for refund, and she was overseas for, several years, does that add to the 4-year provision, or does it somehow does it sort of end? Does it not apply because, as it turns out, she was back in the country at the end of the 4-year period? I'm not sure. I'm just asking if you have any authorities as to how tolling applies here.
Well, the record is not clear. And when we have Exhibit A saying that the appellant left the combat zone on 2/10/2013, and we have a letter of authorization saying the deployment date ended in 2014. It does allow for additional time to file a claim for refund, but it's limited to the period of time you're in the combat zone, and then after you're out of the combat zone, it gives you another 180 days. And so there's, in this case, the appellant didn't meet either of those deadlines. Let's assume that she was in the combat zone until the deployment end date of October of 2014. Then after leaving the combat zone, then she would have another 180 days to file a claim for refund. But that's kind of nonsensical because she was already, if she would have filed in 2014, then she would have been within the statute of limitations. But here, she filed the amended return in 2018. And so the general law in that, and I don't have any cites, but equitable tolling provisions generally don't apply unless there's some specific law. And right now, I don't see a specific law that allows for any tolling of the statute of limitations besides what we've looked at already. I hope that answers your question.
Well, I understand your position. Thank you.
Judge, do you have any questions?
I do not.
Okay. Thank you, Mr. Paval. Ms. Khan, you have time for a final statement if you'd like one.
I would just like to address the Franchise Tax Board mission is promise to the citizens of California to help taxpayers file timely, accurately, and pay correct funds. But you had failed me because we file taxes and it goes back to Internal Revenue and state. And so when it comes back, that's when it's okay. But if it's wrong on our end, they don't catch it. So then we get, it's out on us. So then that's it. So even though I go back, I do my duty in the combat zone, I help, but the extensions don't apply. I've read that there were extensions, it's automatic, even six months automatic extension after you leave the combat zone, which states I did leave at that time. I was going off of the LOA. Again, there's a mistake where it states that that I had left. I didn't leave. That's how it was filed. That's not my fault that it was filed. She put 2012 to 2013. That doesn't mean I had left my combat zone. So I don't know.
Just to clarify, the date that you left the combat zone is the October 1st, 2014
I had left a week prior to that.
Okay, so that's when you returned. And the entry on your return that stated 2013 was inaccurate.
That's just when I came back. I always come back every year for at least a week or two.
Oh, I see. Okay.
My daughter is here, so I just come back for her and then I leave.
And then you return.
Then I return because of the contract.
Okay. And the letter of authorization, the September 16th, 2015 date, you were already here. So are you saying the contract end date on the letter of authorization on Exhibit 4 is inaccurate? So the letter of authorization you brought us today, I think you have a redacted version there too. On the third column over, 8 rows down, it says contract to end date, and there's a 9/16/2015 date.
That's where you renew with the contract again. But
Oh, that's the date to renew. Okay.
I have a question, if I may.
Please, Judge Margolis?
Did you file an amended return with the IRS as well?
No. It was actually somebody from that worked with FTB prior, had just recently left, had helped me, and that's how I understood everything.
Is there anything else you'd like to add that you'd like us to know before we close the record? Okay. Judges, you have any questions? Judge Ewing?
No.
Okay. Judge Margolis?
No.
Thank you. Okay. We are ready to, Mr. Paval? Sorry.
I just wanted to provide Judge Margolis' cite for equitable tolling. 83 SBE 260, 1983. That's it. Thank you. It is appeal of Richard M. and Claire P. Hammerman, Hammerman.
Okay, thank you. We're ready to submit the case. The record is now closed. This concludes the hearing. The judges and I will meet and decide the case based on the documents and the testimony that you provided today. We will aim to send both parties our written decision no later than 100 days from today. Thank you all, and the hearing is now adjourned.
Thank you.
Have a good day.